and that is the changes to non-harassment orders in section 15, and I don't think anyone has dealt with that as yet. I very much welcome this part of the bill, but I don't feel it goes far enough. Many of those who are victims of abuse would benefit from a non-harassment order, but we can see from the financial memorandum this is seldom a disposal that is used. In 2006 there were 24 non-harassment orders granted, in 2007 23, and in 2008 a slight rise to 29. Contrast that with the figures quoted by David McCletchie of 53,681 cases of domestic abuse reported to the police. It shows a lamentable level of intervention by our courts. When I visited Australia and New Zealand in October, I met with people and agencies involved in combating domestic abuse, and I was really impressed at the seamless support that they give. I was especially surprised to see how much of this was being driven by the police and the Justice Department. In Australia, police have powers to put in place a 24-hour injunction without the support or agreement of the victim. These were formalised in court, and justice officials supported the victim through this process and ensured that the court hearing occurred prior to that injunction being spent. There was also a real recognition of the damage done to a child that is brought up as a witness to domestic abuse. Children also have access to these injunctions in their own right. They were able to seek them with the support of children's services. However, children's services could apply for these without the agreement on their behalf. The abuser could then be removed from the home and resources put in place to support the children and the non-abusive parent. The victim does not need to take any action, and they are not responsible for their own protection. The state is. And this protects them from retribution, but also takes into account the distinct nature of domestic abuse. Because domestic abuse is different, it's the only crime I know of where the victim can be complicit in covering up that crime. This is because by the time a recognised offence takes place, the victim has been undermined to an extent that they almost accept what's happening to them. The abuser ensures their confidence and self-esteem is slowly undermined. It's only then the physical abuse starts. In this country, we only prosecute the physical abuse. There is no offence that covers the mental abuse. This means when the relationship becomes violent, the victim often blames himself. In many circumstances, they also feel unable to exist outside the relationship, and therefore they tend to become the best witness for the defence. That's why Women's Aid puts so much emphasis on building a victim's confidence and self-esteem. It's only after this happens that they're able to take steps to protect themselves and their children. In this country, we put the onus on the victim to protect themselves, and this is not the case with any other crime of assault, far less crimes against property. The bill amends the Criminal Procedure Scotland Act 1995, which enables the Fiscal Service to apply for a non-harassment order against a person who has been convicted of crimes involving harassment. While the order is not a conviction in itself, it guards against future harassment. A breach of the order is a criminal offence and can be punished with up to 5 years in prison. An order can be applied where there is evidence of a course of conduct involving convictions for harassment. Therefore, it cannot be applied for unless there is at least one previous conviction for harassment, and the current incident in the court has also led to a conviction. My reading of the bill is that it amends the section in that it lowers the barrier from harassment to misconduct towards a victim. It's not clear from the bill or explanatory notes what the offence that would encompass misconduct against a victim would be prosecuted, or would it lead to a criminal conviction. It's clear from the guidance, however, that a previous conviction is still required, albeit at a lesser charge. These amendments also make it easier to present evidence of previous convictions to the court. However, it does not remove the need for a previous conviction. While it removes a course of conduct amounting to harassment, it does leave a course of conduct regarding misconduct towards the victim. That misconduct will have to lead to a criminal conviction, and it's ludicrous that in this most difficult of crimes to prosecute that a course of conduct is required. If an offence has been committed, then a non-harassment order should be granted. One offence is one too many, and any future recurrence should be stopped. I would ask the Government, therefore, to bring forward amendments at stage 2 which would give us greater protection. The state needs to protect all victims of crime.